Parce que je cherchais pas, puis t'as dit qu'il ouvre.
I told you, all of tab 2 is gone.
OK, merci.
Tab 2.
I went back to the office and there was a chocolate bunny on my desk. Tim Hortons peanut butter. I just need chocolate.
Oh, somebody left you.
Anybody want to eat?
No thanks, I gave up the life. I can't wait.
You want a piece of chocolate?
No thanks. I can't wait for the
put me to sleep.
He said actually not coming.
Oh, hopefully it's still nice out there to go for the swap.
Yeah, it looks a little better too.
Yeah.
No
way.
It's bad when you're calling this looks a little nicer. It's April.
They got Monday, somebody said we're wearing their summer snowboard shorts on Monday. It was like 2023. Yes, they put on the rain jacket because it was raining.
Malonte con lo que es, ¿no?
Back to winter jackets.
Okay, so it's my impression.
It was snowing yesterday.
J'ai Nova Scotia.
So is that a special edition type of vehicle?
Yes.
It's quite nice. I like the blue color.
It's all like souped up.
So how much does one of those go for?
Give them away. There's
No.
a discount. You must get some kind of
I get a
inside
good discount.
yeah.
Where do you
But
get
then I'm
this
trading in
What
mine,
do
it's
you
got
get
20,000
this
kilometers on it.
That
Oh.
machine was for years.
My brother's selling it.
Because you're private.
Oh, wait, but we could pay you for that, and trading in like 2,000 spots, so that's $20,000.
Oh, somebody.
Brand new, it's
So
all
where's the
leather.
different one?
Huh?
Where's the different one?
2 years has passed.
It's better than that, and it's better than legal than that. I could trade it in, so. So better than the Honda
In the winter though, then you could, it's okay summer vehicle.
I bring in
Snow too.
snow, I have winter tires, good winter tires. Well, last time I did get stuck in the parking lot, because that's the first.
So where did you get the original police reports?
Oh, yes. Well,
You guys took something up
They
there.
provide that
let
to
me
you without
suggest
consent or
that
court order.
It was possible
They
that
provided
you
it to me. I read
Driver?
put yourself in that position.
Pardon me?
I made the request and they
Snow in
provided
Can I
it.
have a letter of request?
You know what?
I didn't
Well,
bring
that
the whole
part
file,
there,
so-
but listen, snow there.
Well, normally you're not allowed to get police records without my consent.
Snow. And then
correct?
Yeah, where's the
when
bank?
it's the milk bank.
Let me-
That bank was a bank.
Pardon me?
I sent the letter and received.
Without consent.
We're gonna get out of here. Get your residue.
So was there a breach there on somebody's part?
I don't know the answer to that, Shop.
Well, you require my consent and the police require my consent. Did any one of you have my consent?
You know I didn't have your consent.
And the police knew they didn't have my consent, so how did you get them then? Did you have a court order?
I provided the OCF.
Can you provide me with a copy of that tomorrow?
I won't have, I'm in Sudbury.
Can you have it faxed?
I can ask.
I would like to have a copy. Because you do understand that I will be proceeding against Timmy's police, right? And those reports that you have are all false. Because little does anybody know that I've been recording everything since day one. And digital recorders don't lie. So when we show up in civil court, it's going to be a police report, a video, and an audio of what really happened. So that's one of the reasons why I don't believe you should be relying on that.
Pardon me?
That's one of the reasons why I did not believe that you should have to rely on that. Because Was that not the letter you received right there? On the top?
This is the letter I got.
January 24th. So why didn't you put it in your trial management brief that you wanted the reports then, if you already had them?
No, I was going to submit, and I had never submitted them.
Oh, you were requesting to submit them? I thought the trial management said request to obtain them,
No,
whether court ordered or not.
no.
No, it was to submit. I believe you.
Pardon?
I believe you.
Well, no,
I misunderstood.
but that's it. File.
Oh, okay.
Yes.
What are the dates on the reports that you're relying on?
That are false.
Yeah, which ones are they?
They're the ones from that day.
What dates are they?
But she said I didn't get authorization from her.
What dates are they?
Give me a minute.
I'm doing that because she's out of the room. And she's got Hopkins reports in her own
Are they the
materials.
same ones?
That's what I'm asking.
That's what I bring it in.
May 4th, 6th, 30th. How can you object to that when she's got her own stuff? May 4th, 6th, 30th, and then maybe just go on. So she has 3 such occurrence reports in her own materials.
Which are the ones that
And those are the ones.
There you
Okay,
go.
well, then you're fine.
She was questioning the number.
There you go.
Should ask if you did police officers. Maybe do. As your family member, what is that?
There's page 2. There's a couple page 2. So show them in your clean version. Show them what you'd like to distribute.
So why didn't you ever do stuff?
And then, of course, that's going to be distributed. I mean, there's some questions that come as a result of this, right? Because it is something that people, we didn't get it. I'm sure she has. Just decided that page in.
Oh, it looked like it was there. Look
Where
how
the
many
addresses,
times.
the addresses.
Look how many times the damn thing is mistaken with this thing. I mean, somebody photocopied at some point of that.
They put her addresses.
No.
I know, so that's why she showed up here. Because they had the wrong address.
And the whole page.
Yeah.
It's an honest
Yeah.
mistake.
So my preferred practice
You're
rather than this is to do this with him and allow her to do whatever questions she has as a result of this new production. And then
Or like,
okay,
what? You have to bring up letters.
Yeah, okay.
That's a cross-examine, whatever, show up
based
based
on
on
this
later.
production.
And then on to my questions. If you have any questions, you go.
Yeah, I don't really have any questions. I don't know why you think. There's no point. She's got them in there.
What do you think?
What do you want to do? You want to have the market activities? Well, there should be. It's in her stuff. You can't
They're
object to
already
that.
there.
But I don't know if he's
But they're
necessarily,
not exhibits yet.
and he's not necessarily going to make any
Yeah.
exhibits.
So put it in, we'll all agree, and she can't disagree. This is her
It's in her
stuff.
book.
As to what actually did happen.
But
Who knows?
Who knows if it did happen? No.
It's all
If we lived in Toronto, we wouldn't know anything. But that's we lived in a small little town like this. We're connected to
It's tab 5.
It's Lalonde.
You can reference it if you want. Volume 2
L8.
and
E on the end.
tab 8. You're in here too.
Right.
You're at tag drawing, by the way.
Other
Unless you have
sections.
nine, what did I say? Oh, yes.
Just saying.
Oh, look at, they're recording. Somehow, I didn't have to send it at the time, that's the funny part. It was like foreseeing to the future.
Then they should
I didn't have to send it at the time. Do you remember this?
What was his initial?
It's actually in that college place. But I go to these about the comment. I had that time to do that.
Okay, you sound like you're getting stuck. Oh,
That's for yourself.
sounds like it's been, yeah, yeah.
It's just this word, yeah.
Yeah.
In case an allegation or something.
It's so cool to see.
Just call Michelle and I'll
Oh, no, just me.
Oh, yeah.
And the thing is, I didn't have. She's gonna ask me. Whatever you have to do.
That part's not true. You just can't talk about what's going on. So you can talk about whether the population.
I said just to be safe, I said just stay alert.
She probably.
She's cool too, she's not cool about you, she'll learn English.
There's nothing, because I'm not out there.
Yeah, but then she told me something along the way, she talked to me and everything.
Yeah.
Oh, that's so cool to see.
Where are you?
I should start about
What
civil,
tab is
I
that?
should start about civil suit, look at that.
Order all rise. Curtis, you're taking me to see the
Perhaps I'll take a moment and see if I can locate the officers.
Can't locate issue and climb up and down the halls. Issues.
Okay, well, thank you. We'll just have to wait.
smoking.
Should be a box of water.
Would you mind removing that copy?
Oh, I'm sorry. Here. Thank you. Thank you.
Your Honor, in case you didn't notice, I am back.
Oh, thank you.
Ms. Petty suggested I mention something.
All right. Okay, thank you. So, Ms. Mendoza?
Your Honor, what I'd like to do, subject to your approval, is that
Here for Justice Small Claims Court in session, Deputy Judge Young presiding, please be seated.
Good morning.
Good morning, Your Honor.
Gentlemen, you understand has served some material internal this morning, is that correct?
Yes, I did file a notice without motion that was required to be brought forth due to the circumstances. And so I brought that motion into Rule 15 for motion without notice, which was filed 2 days before the hearing. Yes, it was served and filed. Yes.
We have been served with a copy of the plaintiff's notice of motion. So I think it's to strike out the defense and our motion.
Yes, and that was served and filed 2 days before the hearing on Monday.
Served 5 days before I think.
It's a notice without motion, so it's
Not a notice without motion, it's a notice without motion.
well, I've given notice, but it was brought under, I was only served with their notice on the 31st. So it's it's responding materials to their motion. It's the factum is in response to their motion, and then my motion is a cross motion. Which were all filed pretty much 2 days before the hearing. Yes, I would agree that's when you're bringing a regular motion, but this motion is made without notice.
Well, Your Honor, that's one issue that I'm not overly concerned with. We were served with the motion material 2 days ago. I've had a chance to look at it. I don't know if Your Honor has had a chance to look at it or not. Or if you...
No, I'm not.
Okay. The way I read it, it's a motion seeking to strike out the defense, as disclosing no reasonable defense. And in order striking out our motion to strike out the plaintiff's claim. I see this motion material primarily as a defense to the motion that we have brought. But I have not had a chance. I had a chance to review it. I haven't had a chance to really turn my mind to whether I need to respond to it formally. But I was prepared to deal with that today. One other complicating issue that has arose this morning, unbeknownst to me and without any notice to me, Ms. Jelena has filed a fresh and amended plaintiff's claim, and she showed me a copy. I cannot accept service because I don't have authority for my client to accept service of a claim. But there is a new fresh and amended plaintiff's claim that was just filed with the court and stamped this morning with extensive allegations in there. I don't know how many paragraphs it contains, but it's extensive.
My court provided me with a copy of this.
Okay.
Dated April 12th, issued April 14th.
Well, there's one amendment that was just made this morning.
I'm sorry, I'm the wrong one here. November 7th, and issued on November 10th, which is today.
Now, I'm a little bit put off because if I've had prior notice of Ms. Jelena's intentions to do that, I wouldn't have spent yesterday preparing for this motion driving up here. And Your Honor, likewise, and I mean, I don't know how we can proceed with my motion when we've got a new statement of claims that hasn't been served on my client yet. And I'm concerned with whether my stay is now a waste of time, of everybody's time.
I'm also concerned about that. What do you have to say about this? Why didn't you do it 3 months ago, 6 months ago, and give the parties a chance to respond?
Because when they served me with their defense, they included an exhibit that had never come to my attention, which kind of was newly discovered when they served me with the defense, which caused me to realize that, you know, they were more liable than I thought they were in essence. So I had to amend my claim considering the discoveries that I made through their defenses. And furthermore, the rules do state that I can amend my claim anytime 30 days before trial. The other issue that I have is that I was served with a notice of settlement conference without the court giving me 14 days prior notice of such.
We'll deal with that at the
Okay, yeah.
I'll deal with that in due course. We're not going to have that at this point.
Okay.
I'm more concerned right now with the motion that's before the court. And of course, the motion that's before the court is based on the statement of claim that you issued many months ago.
Right, and the notice of motion that the defendants have brought, they don't really have standing to bring it because they haven't abided under the Business Names Registration Act, and that's clearly stated in my factum.
That may be a position.
Yeah.
That may be up to the court to decide. That may be one of your arguments.
Well, that's one of the reasons why I brought the motion without notice, because I had anticipated that we'd had a settlement conference where a lot of these issues could have been brought up there. But considering the defendant's, litigation strategy to try to summarily dismiss my motion this morning, without really, they don't have legal standing to do so, I was forced to bring a motion without notice to say, hey, to the court, to say that they can't do this morning. Their defenses can't be accepted by the court. And neither can their motions.
In your position.
In my position?
That's up to the court.
Yes, yes.
I can tell you that preliminarily, the counsel for the defendant does have the right to bring a motion as they have done.
Oh, I agree with you. If they were compliant with the Business Names Act, yes, but they.
What's the Business Names Act problem?
Well, the Business Names Act problem. The business is Paddy's Law Office. Paddy's Law Office is not a registered business. So they have filed a defense under Paddy's Law Office. They've responded, they've brought motions under Paddy's Law Office. And under the Business Names Act, it clearly states that the Act makes it an offense to carry on a business under a business name without registering. It also renders an individual who carries on business in violation of the Act incapable of maintaining an action in connection with that business except with leave of court. And that's also found under Rule. They can't participate in the action without. No, they cannot. It says right in the case law. Well, the rules are pretty clear.
Please interrupt me. Please interrupt me.
I apologize.
The position that the court is taking is that the defendant is quite entitled to respond to your claim by way of a motion of this kind. Okay, that's the first position. Now, what concerns me, however, and concerns me very, very much, is the expression of this plaintiff's claim that has not been served and yet shows up on the court's desk 10 minutes before the motion is to proceed. And I assume, I haven't read it in detail, I read through it, I assume it changes in some significant manners your claim. Is that not correct?
Yes. The only reason why I filed that this morning, Your Honor, is because I was here, and I got it issued, and I served it upon the opposing party. But going back to the Business Names Act, it clearly states that they are not entitled to maintain a proceeding. Well, that's the law. Well, then why are we here?
Thank you. This is called court.
Yes, and I'm sure.
This is called court.
Yes.
In court, there's a judge and there's litigants.
Correct.
And you have to be courteous and polite, as do I. I'm the judge. So let's all try and get along. Now, I'm concerned, as I was expressed before, with what we're going to be able to do today, because I don't think in the face of this amendment, they can proceed with their motion.
I concur, Your Honor.
Now, we're here, and a lot of time, and a lot of effort, and a lot of money to get here. Let's talk about tree crops. Now, you have, Ms. Bell, any concerns about having a pre-trial today because you weren't properly served. Is that correct?
Yes, the rules clearly state that I'm supposed to be given at least 14 days notice by the court to file my documents. It's clearly stated on the form that I have to file my evidence and everything that I require 14 days before the settlement conference. So considering the court only gave me 9 days notice, kind of puts me at a disadvantage to attend the settlement conference without being able to file my document according to the rules. So a lot of the issues that I brought in my motion without notice, I was hoping to deal at a settlement conference until I was served with their motion to throw out my documents. And unfortunately, I would hate to disagree, but my facccking clearly states, and the authorities that I've attached clearly state, that the opposing party have no standing to bring a motion or participate in the proceedings until they're registered under the Act. It's the rule. It's in my factum. It's under Business Names Act, Section 2 and Section 7. It's also under the Corporations Act. Clearly states that a person carrying on business in contravention of that rule is not capable of maintaining a proceeding in a court. The authorities also state that the party can be sued, but they cannot respond unless they're in compliance with the Act. So the only person really who could bring a motion today or file a defense in this action is Lisa Parizet in her own personal capacity. She has not done so. The defenses that I've got are from Rene Parizet, who is not even a defendant to this action. He's not a named party. So he added himself as a party, joined himself into this action without seeking leave of court. So he can't really defend this action, and he can't defend the action under Parizet Law Office because it's not a registered business. The only person who can defend is Lisa Parizet on her own proper defense, but she has not done so. She's filed a defense in association with Parizet Law Office on the same defense. So we can't have joinders of parties to this action who don't have standing. And that's my position. I was hoping to deal with all this civilly, discretionally under a settlement conference to give them the opportunity to be in compliance with the Act to continue the action. But being forced with a motion to dismiss my claim summarily, which is not really an option in this court, as per the case laws, unless it's plain and obvious that my claim can't proceed or doesn't disclose a cause of action. So I think we're kind of rushing ahead to try to breach my rights by trying to set a settlement conference date 9 days notice before a settlement conference, expecting me to file my documents 14 days before, having a motion brought by the opposing party by defendants who have no standing to proceed in this action, and under a procedure that's not available in this court. So quite frankly, I'm not sure what we want to do today. You're in charge. I just want to bring forth my position, which I think are valid and they're supported by Supreme Court case law, which is binding on this court. Thank you.
There's a lot in there. I'll just parse out the issues that I do want to respond to, Your Honor. Beginning with the business names, I mean, you made a ruling on that, and I'm satisfied that we can defend this action. The plaintiff has named the defendants, and we're defending it. In terms of who the identity of the defendants, the plaintiff's claim, the initial plaintiff's claim, named Lisa Perizet and Perizet Law Office, and the defense has been filed to that claim by both those defendants. After that claim was served on the defendants, Ms. Jelena served a notice to alleged partner. That notice to alleged partner was served on Réjean Perizet, alleging that he was a partner with Ms. Perizet in Perizet Law Office. Because we were served with this notice of alleged partner, it says right on the form that if you deny that you're a partner, you have to defend it. So Réjean Perizet, Mr. Réjean Perizet, had to defend this action in light of this notice to alleged partner, defending the action and stating that he is not a partner. It is not a partnership. So that explains why there's a defense from Mr. Réjean Perizet.
That's all correct, why he's correct in his law.
Well, Your Honor, I agree, but under Rule 506, it says that a sole proprietorship, if a person carries on business in a business name other than his own name, which is Réjean Perizet, carrying on business as Perizet Law Office, a proceeding may be commenced by or against the person using the business name. Rule 501 and to 505 apply with necessary modifications to proceeding by or against a sole proprietor using a business name as though the sole proprietor were a partner and the business name were the firm name of a partnership. So that is why I served the notice of alleged partner. Not because I was claiming he is a partner, it's because under Rule 506 it clearly states that a sole proprietor carrying on under another business name other than his own name is considered a partner to the firm name. And so even though whatever reason they want to state that Réjean Perizet is defending the action, he can defend the action under Perizet Law Office, but he can't defend the action in his own personal capacity and add himself as a third defendant. He's not filing a counterclaim here. It's not a defendant's claim. It's actually a defense, and so he's adding himself as a defendant to this action. He could respond to defend Perizet Law Office. He could sure do that. But he can't add himself on. That would be like 100 different people working for Perizet Law Office or being partners trying to respond to the claim. It doesn't work that way. Second of all, Perizet Law Office is not a registered business. And so even in that sense, under the Act, Réjean Perizet cannot even respond under the Business Name Act. And I obtained the statement of no match found, the nuance search, and I've sent out the $60 to the company's branch to provide me with the expired business registration that expired in 2014. I haven't received it yet. I just ordered it. It's going to take time for them to process that. I thought I could do it online, but it has to be done either at the office or by sending. So that kind of puts the brakes on what I was able to do there. But I did file in my documents the notice of statement of no match found, which means that there's no business registered under Perizet Law Office under that business name. The nuance search, which shows that that business name is available. And the company's branch, which advised me that the business registration of Perizet Law Office expired in 2014. So they've been operating a law firm under Perizet Law Office, holding themselves out to the public as Perizet Law Office without being registered under the Act, which is a criminal offense. And they don't have any standing to respond to this matter today. Bears versus Scobie, in my authority, clearly states that there's a prohibition in the Business Names Act that prevents a proprietor who has not registered from suing in the name of the unregistered business, but it does not protect such business from being sued. Rule 807 permits a sole proprietor who uses a business name other than his own name to be sued using the business name. But the main purpose is to ensure that if a person has a claim against the business, it may sue the business and obtain judgment against the individual, as well as the assets in the business name. That's under Bears versus Scobie, which is at tab 7 of my authorities. Furthermore, the Corporations Act, if they let their business name expire and they went under and went and formed a corporation, even under the Corporations Act, the same rule applies that a corporation is in default of a requirement under the Act to file a return or notice or has unpaid fees or penalty, is not capable of maintaining a court proceedings in Ontario with respect to that business carried on by the corporation except by leave of court. Now, they obtain leave of court, but the court shall grant leave only if it's satisfied that failure to file the return or notice or pay the penalties or register the business name was through inadvertence, which I highly doubt it is, considering Paddy's law office state that they practice in the areas of business law. I'm sure they're fully aware of their obligations, that there was no evidence that the public has been deceived or misled. I'm not quite sure that the court could come to that conclusion based on this quick hearing today, and that at the time of the application of the court, the corporation had filed all their returns noticed by the Act. And it's pretty clear and stated by Justice Balin in his decision, stating that the court should consider disciplinary purpose of the Act. The court should not restrict its right to grant leave to businesses that inadvertently fail to register, but to do so would be to federal discretion. However, it should grant leave only in exceptional circumstances, because to do so otherwise would considerably weaken the disciplinary purposes of the Business Act and the Corporations Act. And so we're here today to hear a motion by Régent Parizet, who's not a party, Lisa Parizet, who is a party, who has standing, and Parizet Law Office, who does not have standing. So, of course, I'm going to bring a motion without notice to say they can't even bring this motion to dismiss my claim, number one. Number two, their defenses can't be accepted until they comply with the Act and show proof of compliance, and they have to get leave to remove the stay before they could even proceed. So there are rules and technicalities, and we're not going to take shortcuts for the opposing parties here who are basically trying to ambush me unlawfully against the rules. My cause of action does disclose, my claim does disclose the cause of action. They've admitted, specifically in paragraph 12 of their factum, that having reviewed the documents released by Timmins Police, Lisa Parizet realized the documents included the plaintiff's records. So she admits to having requested and reviewed them, which is right there an element. Pardon me? No. In her claim, she requested them to the Timmins Police. Well, in her letter, she states the parents. The parents provide me with the information of the parents. She didn't have the parents' consent, nor did she have my consent to file my personal information in the requesting the records.
Let me just stop it.
Mm-hmm.
I know you've lived this, and it's a very, very, very important part of your life, and it's a huge amount of time and effort on this. And you're a passionate person, I can tell that. And you're very, very concerned about the rules, of course, not adversely affecting you. Correct?
Well, I'm concerned. Yes, I'm concerned. Yes.
Yes. Come here today, and you file a new statement of claim. It's not absurd. And those rules don't work in your favor. They work contrary to the thing.
Well, I tried to serve.
That's a very serious
Yeah.
thing. So you want everything to go your way, rule-wise, but you're prepared to kind of waive the rules when it affects the other side. So that's a problem. It's a problem for me, because I've come a long way to try and deal with something today, and I can't see how I can in the face of this amended statement of claim.
Well, the rules clearly state that I'm able to amend my claim.
Please, I'm not finished. Now, I understand from the court office that there's a companion action here against the Indigenous police. Is that correct?
It's a totally separate action.
Involving the same facts.
Involving separate facts.
Involving the same facts.
No.
And that there is a settlement conference in that matter scheduled for December.
Actually, that matter is in regards to the creation of false records that were disclosed. That has nothing to do with privacy breach.
you aware that that happened?
Not aware of it at all, Your Honor.
See, this was my big question when I started looking at the thing. I just said, wait, they're the ones that bring your privacy.
No, they didn't. Your Honor, I'm not sure if you've had a chance to read my factum, but it's clearly stated in there what occurred. And my amended claim clearly states that, well, obviously you don't, because Ms. Petitze requested the records, obtained them without my consent, knew she had them without my consent, held on to them for a year and a half, then was caught red-handed with my police records in hand, in trial, disclosing them with other parties, disclosing and sharing them with other parties, knowing that she did not have authorization to have them, concealed them, walked back to my table, tried to deny that she had them or that she could have them with my consent, and if she didn't do anything wrong, then why did she take the action to go steal them the following day? Now, what would have happened if I wouldn't have noticed she had my records? It is a complete breach of my rights, and there's no actual law or rule of law that states that Lisa Petitze had the authority or consent or authorization to obtain my records. Meanwhile, there's Freedom of Information, the Privacy Act, the Personal Information Act, actually the court order appointing her. I think the police are going to say that they released the records to Ms. Petitze because she misrepresented the facts in her request, that she had consent of the parents. She didn't have my signed consent, but she mentions that she has consent. No, the crux of my case is Ms. Petitze obtained the records, whether or not they were released to her or not. Under the Act, she had no right to keep them.
The police dropped the ball, didn't they? Didn't they misread the documentation, which Ms. Bridget was quite...
That's not where my claim stands.
Quite capable and correct in her opinion.
No, she was not.
And released your records. What's your claim?
She held on to them for a year and a half. My claim is in regards to her sharing and discussing the records in an attempt to put me at a disadvantage in a trial. She concealed an unlawful disclosure for a year and a half to her benefit to cause me harm. That is what my claim is in regards. Has nothing to do with the actions of the Timmins police, has nothing to do with the child protection proceedings, has to do with my personal rights to privacy, and it has to do with her failures to follow those rules of law. If they could provide me with a rule of law that says, yes, Ms. Petitze had full rights to keep my records for a year and a half to do as she pleased, if they could find that law, then they have a defense. If they cannot find that law, they have no defense tenable in law. And in my opinion, yes, and that's my argument. And also in the...
What I'm trying to get to here is some way of dealing with what we're up to here. Now, I don't think there's any way I can hear this motion based on the news. You're going to have to revise your material, looking at this revised statement of claim and seeing if you can respond to it and so on. Now, I'm here. Would you like me to go in the office with your bowl and have a off-the-cuff pre-trial?
No, I'm not in agreement with that. Sorry, Your Honor. We're going to deal with these issues before the court, and if there's a decision that's adverse to me, I will appeal it. That's all. And then we'll continue.
I'm not talking about a formal pre-trial. Oftentimes in contentious litigation, regular in superior court, there's many, many pre-trials. I'd be happy to talk to you both about this case.
I would rather this be on record. But thank you for the offer. We're going to comply with the rules, and I'm going to get proper notice of the settlement conference. We're going to attend that if that's the case. And whatever's disclosed there will be disclosed there. But until that occurs, we're not going to go behind closed doors, off record, and discuss this matter. We're going to put this on record, and we're going to make a decision according to the law and the rules. And I filed all the documents that I need to. I have the arguments that fully support my case. The defendants have no defense. And if they could prove that they had proper authorization or right to have kept on and held on to a disclosure unlawfully for a year and a half with the sole purpose to assist other parties and discuss them and share them and conceal them, if they had the right to do that, then then maybe we could discuss about trying to dismiss my claim. But with their admittance of actually having reviewed and decided whether or not they were relevant, she had no right to do that, period. As soon as she knew she got that disclosure without my consent, whether or not the Timmins police released it to them by error or through inadvertence or with their specific intent to harm me, the point was Miss Petitze did not act like she was supposed to act like a professional. Under the court order that appointed her, it clearly states what her statutory obligations were. It says, on paragraph 4 of that order, upon the children's lawyer obtaining authorization signed by the parties and others involved, then she could request records. In the police side of it, it also says where they also need to follow paragraph 4 before they could provide the records. So both parties knew what their obligations were, and the reason why I bring my claim is because I've been constantly shown by opposing parties that apparently I have no right to privacy or anything. And quite frankly, I'm entitled to enforce those rights, especially when an unlawful disclosure is provided containing some very defamatory information, which she shares with the opposing parties with the intent to cause me harm. I recorded the conversation with her, confronting her, where she admits there was no court order, she did not have my consent. She knew she did something wrong. She also knew that she was concealing speaking with them about them with the opposing party. The opposing party also knew that she got them without consent because they were all secretly discussing them, which shows me that there was some intent to cause me harm. Had I not recognized that she had my original police records in hand, they would still be sitting in the Office of the Children's Lawyer file, or they would have been submitted in court to be used against me. There's a reason why I never signed consent for those records. They're false. And that's what my claim against the Timmins police is about. Creating false records, fabricating records, of which I have a lot of evidence about.
Okay, so your claim against Timmins police is not for disclosing these records?
It's for creating the false records with the purpose of disclosing them.
Is it for disclosing them as well?
It's for disclosing them as well. But the most biggest part of it, which includes at least 7 police records that were fabricated of events that never occurred, things that I was never spoken to, which were highly offensive. So for Ms. Petitze to have had this disclosure of all these records, and she didn't just have Timmins police records, that's all she admitted to. But she got the OPP records, she got my medical records, she got school records, she got all kinds of records without consent. Now, being a lawyer, she's held to a higher bar. It's not like, I didn't know the law. She knows the law. She knows what her appointment was in the court order. She knows what the privacy laws are. And I'm fully aware of the privacy laws myself. And when an accused in criminal court is before a court and their rights to disclosure or whatever, their Charter of Rights are breached, there's some serious ramifications. There's no exception to the rule. She can't say that I couldn't have reasonable expectation of privacy because of the proceedings that I was involved in. That has nothing to do with anything. I'm a person, an individual who expects that if somebody receives my mail, my neighbor receives my mail, they're not going to open it and read it and keep it and hold on to it for a year and a half. They're going to open it, realize, this is not meant for me, return it immediately. That's not what Ms. Petitze did. She actually did completely the opposite, and she purposely concealed it because she was assisting other parties to put me at a disadvantage. The conversation she had with the opposing party that was overheard by my mother and I, which was actually recorded, was her having a discussion with other parties on how they would submit this unlawful disclosure and cross-examination to put me at a disadvantage. Now, that disclosure has been sealed in a court file, but I'm on appeal with that matter. So at any time... No, I'm actually going through appeals. I just got out of the divisional court where the society was ordered to pay me $3,000 for failure to provide me with disclosure. And I've appealed to the Superior Court with respect to the decision that was reached based on false records. And so that envelope's sealed in that court, and at any time the opposing parties could decide, we're going to bring a motion to unseal those records and to be used against me, when those records should have never been filed because they're false. And I have tremendous evidence to support such facts. So unless the opposing parties could provide me with a rule of law that says that they were allowed to have special override privileges over my rights, then we could proceed. If not, then their defenses should be struck as disclosing no reasonable defense, and considering they're committing criminal offenses by carrying on a business of Petitze law office, without them being registered is actually it's a criminal offense under the Business Act, the Corporations Act, and under the Consumer Protection Act. And they're all provincial offenses that can be prosecuted, just for that simple fact. So there's been many incidents of disclosure violations by Lisa Patisé. This was not the first isolated incident. There was another incident where she received 18 pages of individuals that were unknown to me that had some very serious issues discussing about adoptions and abuse and sexual abuse. And these records were passed off in a court file before a judge without my knowledge. And she received that disclosure of 18 other families. She wasn't allowed to receive that. When I made her aware of it, she didn't even want to bring any motions to take it out of the court file. I had to make a complaint to the privacy commissioner and argue with the society and other people that these disclosures that belong to 18 other people should not be in my court file. And so eventually the privacy commissioner investigated, the society brought a motion, but those records weren't destroyed. They're again sealed in my court file. Now those records that are sealed in the court file, it's pretty clear that any judge that would read them would pass them off as belonging to me. So the issues of privacy concerns with Lisa Patisé started long before this. And there's been a lot of breaches of my rights throughout the proceedings. And this claim has nothing to do with child protection proceedings. She can't say, we could have brought a motion under Rule 19. Well, you could have, but you didn't. So any pleadings in regards to alternate defenses offered can't be pleaded because they're just inserted for color. They're just there to try to distract from the fact that she had an unlawful disclosure that she kept and held on and concealed for a year and a half. It's fairly clear that the proceedings in the small claims court don't support a summary dismissal of an action unless it's plain and obvious that the action can't stand. And it's been stated consistently in the Supreme Court in Hunt versus Carey or Hunt versus TNN. The authorization of the order appointing her clearly states she needed to obtain my consent. So unless they could provide me with a rule of law that says that my Charter of Rights, my freedom of information, my privacy rights, and my rights in a court were not breached and that they had full authority, that's fine. But they can't plead that, we could have brought a motion for the disclosure and eventually they would have been disclosed. That's not what occurred, so don't plead that. Don't plead the alternatives. All their case laws that they submit in respect to their claim is all dealing with family law matters, which are, quite frankly, not relevant to these proceedings. This is an invasion of privacy, intrusion upon seclusion, making private facts public. This is what my claim is about. Has nothing to do with child proceeding, and any reference that's being made to previous proceedings identifying my child, or identifying me as a party, or even mentioning the World Child Protection Proceedings in this claim is a breach of a publication ban, which they're liable for a fine of up to $10,000 or 3 years in jail or both. And considering that she is the lawyer to the child, she's breaching client solicitor privilege, which she has a duty of loyalty to her client to keep confidential. So there's a lot of issues with the defenses filed and a lot of issues with the motion that has been brought. I'm not just going to sit here and say, okay, well, we're just going to proceed like summarily, just dismiss your claim, not give you notice, 14 days notice at least to file your documents, and if you don't file your documents 14 days before the notice of settlement conference, your action could be dismissed or have costs drawn against you. So the court sending me the notice within 9 days, expecting me to file my document within 14 days, is a clear infringement of my rules, my rights, and of the rules. And this is why I'm here, is because people seem to think that the rules of law and my rights don't matter, when they do. We all have equality under the law. And my rights to privacy are just as important as anybody else, and I have reasonable expectation of that, considering the light of the proceedings I was involved in and the trauma I suffered from reading those records in itself. And those are my arguments, and I believe that my factum and all the authorities that I submitted clearly support that my action should not be struck. and clearly support that they have no right to maintain an action, especially les gens parisés. Thank you very much. I apologize. I'm very passionate about this.
I appreciate your passion, I appreciate your concern.
Thank you.
I'm looking at Section 82 of the most recent claim, aggregated punitive, non-pecuniary, nominal, consequential, general, and exemplary damages, special damages, compensatable. $25,000. Now, after hearing your passion, submission about the complexity of this matter, I have some concern that it doesn't fall within the ambit of Rule 25, small claims court, which says that the small claims court may hear and shall determine in a summary way all questions of law and fact, and may make such order as is considered just and agreeable to his conscience. So that really tells the judges of small claims court that we're dealing with something else. We're dealing with smaller matters. We're dealing with things where people do not have to have counsel, where oftentimes the rules are relaxed. So, reading your pleadings, and particularly your prayer for reading, you are relying upon some significant statutes, like the Freedom of Information Protection and Privacy Act, the Municipal Freedom of Information Protection and Privacy Act, Personal Information Protection and Electronic Documents Act, Privacy Act, Access to Information Act, the Constitution Act, the Charter of Rights, Personal Health Information Protection. I am concerned that this matter perhaps ought to be transferred to Superior Court of Justice pursuant to Rule Section 101. That section. 110, sorry. So what do you think of those thoughts? Is this something that we ought to consider? Is this something the Superior Court ought to be looking at?
Can you give me a second, Your Honor, to look at that?
I'm concerned, Melanie, that I might not get a hearing in this court in anything more than a summary matter, and your concern are far more complex than this court is designed to remedy. Or the Superior Court is designed to respond to claims of this nature.
The leading case, Jones versus Things, Tinge, I don't know how to say their names there, they started off in small claims court. It was a small claims action that eventually led to the appeals court. But I don't believe that the tort of intrusion upon seclusion or breach of privacy is worth more than $20,000. So that's the reason why I brought it to small claims court. Now, really, under the rule 21 or 23, the rule that you just mentioned of dismissing summarily, that's in good conscience.
Talking about the rule that we're governed by, it's section 25.
25?
Here. It's just like section 25.
Yes. Small claims court shall hear and determine in a summary way all questions of law and fact, and may make such orders as it considers just, agreeable to good conscience. That is in the course of the proceedings. I agree that that rule applies. But in the pleading stage, and in the stages that we're at right now, there's no procedure available to bring a motion to dismiss or strike out my claim if it discloses a reasonable cause of action. I don't really, well, if it's under Rule 12.
Your Honor, I don't think this, I agree with Ms. Jonah that this is a claim that's based on the intentional tort of intrusion upon seclusion. The damages for that tort have been found to be, by various courts that have addressed the issue, within the jurisdiction of the small claims court. I don't think it'd be fair in these circumstances to my client to serve them to the increased costs procedurally and otherwise of bumping this matter up to the Superior Court. I think it is a matter that falls within the jurisdiction of the small claims court and not to be resolved.
It clearly falls within the jurisdiction, but it's such a complex matter that I'm concerned about proper hearing, really satisfied that both parties being held.
I think a trial.
You're not going to get any judges who are conversant with all this privacy material, I don't believe. We're not trained in it. We're at the court to start. And that alone is important to you.
The procedure is much more complex. Privacy breaches and intrusions of privacy have been brought in small claims court in these circumstances, but if it's a breach of a federal act, like the Privacy Act, that's usually brought into federal court, not the Superior Court. So I'm not quite sure why I would want to risk a more complex procedure and more increased cost by bringing this matter to Superior Court. Because if I thought the claim was worth $50,000 or more, I would have brought it there. But I don't believe it does fall into that category. But I do believe that there has to be some kind of a resolution and accountability in what has occurred, and I should be, put back to the position I was before everything started. And it does state in the case law, Jones versus Sings, that the damages for intrusion upon seclusion in cases where the plaintiff has suffered no pecuniary loss should be modest, but sufficient to mark the wrong that has been done, which is usually within the range of $20,000 or less. Which I feel my claim is properly framed for the small claims court.
If I may add one thing to address the issue that you seem to be concerned with, is privacy legislation. In a whole, that legislation does not govern the requests that people can make to institutions for the release of documents. There's no restriction on requests that people can make for documents from private or public institutions. All the privacy laws govern what institutions which maintain private information can disclose. So in that respect, although that privacy legislation would be relevant to any claim against the Timmy Police Department, or police services, they're inapplicable to the circumstances involving these terrorists in making a request for documents.
Again, the order appointing her clearly states at paragraph 4, upon the children's lawyer obtaining authorization signed by the parties. That's the order appointing her. That was her statutory obligation. There's no other way around it, unless she would have wanted to bring a motion under Rule 19. Then I could have argued that the relevance and reliability of the records were inconsistent with the purpose of the best interest of the child. Furthermore, she wasn't appointed to make a lawyer's report under Section 112 of the Court of Justice Act. She was appointed under Section 89 to represent the child's wishes, which is going to the court and saying what the child's wishes are. Not to act as a second lawyer for the society and be an instrument to obtain all these unlawful disclosures, to be concealed and consulted with the other opposing parties, to be used against me, which are still sitting in the court file right now, that could be unsealed to be used against me on appeal. That does not remedy the situation. If Ms. Patizé didn't do anything wrong, why does she have the records sealed?
Well, there's a couple issues I think I'd like preliminaries or procedural issues that ought to be addressed, Your Honor. I just learned about this companion action involving the Timmy Police Service. I mean, it was always on my mind why the Timmy Police Service wasn't a defendant of this action. I couldn't understand that. Now I do. If that's also the small claims court, it would be my position that these two matters ought to be heard together or one after the other, because it seems that they are involved the same set of facts.
And what about having the settlement conference at the same time?
I think that would be appropriate.
I would disagree that the claim should be joined because I'm seeking $25,000 from each party, number one. Number two, what happened with Miss Petitze in the course of those proceedings is completely separate from the disclosure that the Timmins police made of records that they falsely created for the purpose of it causing me harm. Now, if we're going to bring those actions together, then we're going to say that they all conspired together, and I'm going to add a conspiracy component to the claim. Otherwise, we're going to separate them, and Ms. Petitze could take responsibility for obtaining and receiving a disclosure she knew and admitted she didn't have, that she admitted that she reviewed to see if they were relevant. She admitted right there to the elements of intrusions upon seclusion. It clearly states that in Jones versus Kings that intrusion upon seclusion also includes opening private and personal mail that doesn't belong to you, or where there's no publication or any use of the kind of information. So what Ms. Petitze did is completely separate from what the Timmins police did. The Timmins police, I had a Human Rights Tribunal application against them. I had Privacy Commissioner complaints against them. I had requested access to correction of information and records. They knew all this and disclosed the records to Lisa Petitze. They could claim that in their defense, that's the only reason why they disclosed them to Lisa Petitze is because in her letter, she misrepresents the facts and states that she wants to receive the disclosure of the parents. She puts my name, my date of birth, and my address. That's my personal information. So she breached a privacy law right there by sending that to the Timmins police. And she says, please advise whether either parent has a criminal record, including CPIC information or occurrence reports that have been filed involving either parent or the family. This is a misrepresentation of facts. It's conveyed to the party receiving it that she has consent of the parents. I'm a parent, but she did not have consent. So for her to make the request for the information of the parents, the person at the Timmins police could have easily looked at that real quick, said okay, and saw the authorizations of the father that was attached. Yeah, so the father is the authorization attached, and the father's spouse. No. And in this actual authorization that's signed by the father, the child's name is incorrect. Child's name's Emily Genina. That's not the child's name. So even this authorization did not allow the Timmins police to release any records. Now the Timmins police released other third-party records of my ex-spouses that also identified me without my consent. So there's a myriad of issues.
Okay, I want to take 10 minutes. 10 minutes?
All right. Court will recess for 10 minutes.
Do you mind if I?
You do? Sure.
Little touch. Thank you.
all ayes. Court is on Zoom. Please be seated.
All right, what can we accomplish?
I'm not sure we can accomplish much of any substance, Your Honor. I'm in your hands. I mean, we can deal with some preliminary procedural issues. I note that today, Ms. Jelena, on the record, gave the child's name and whatnot. So, given the privacy issues around that, I note that in her materials that I've reviewed, she's seeking that the file be sealed, and I have no objection to sealing this file. If she wants it sealed for privacy issues.
I'm requesting that it be sealed, but I'm also requesting that irrelevant referrals, like every sentence of her defense, she puts child protection proceeding, child protection proceeding. It's almost like they're putting that in for to insert color, to discredit me, or to humiliate me. It's a breach of a publication ban. She's not allowed to talk about previous proceedings, and it's in my factum. The rules are fairly clear on what's under the Child Family Services Act. She can't identify or make public information. Well, her plea must be struck for that reason.
I'm not prepared to do that. I am prepared to order that the plug out the PEDO.
And a publication ban be applied? Because it's actually under operation. The mandatory statutory publication ban under a child protection matter doesn't expire by these proceedings, which are public proceedings and public records. Now, if she intends on continuing to do so and identify the child and myself in child protection proceedings and other parties, she's breaching a publication ban. And yes. The other issue as well is I apologize, Your Honor. I just wanted to bring up a few other key issues. It's already been ordered, Your Honor. It operates under, well, it's already been ordered, but Ms. Petitze has breached it in her pleading, so they must be struck then. Well, if these pleadings aren't struck and they're meant to be public records, then I'd like for you to make an order refusing to strike that, and I'll appeal such. Because my whole claim surrounds privacy breach. We're not going to breach my privacy further. I did bring it in my motion for a publication ban. It's a motion without notice that does not need to be properly served and filed. It's a motion without notice, and it's properly before this court. And I won't appreciate being put in a position of bias by a judge who thinks that the rules don't apply to me at all in this matter. Well, then we're going to follow them. We're going to throw out their matters because they're non-compliant with the Business Act. They have no right to have pleadings before this court right now. So there's many arguments that have been stated in my facts, and then the authorities that support that are far beyond the authority of this court. And quite frankly, I feel like I'm being legally bullied, and I'm not going to put up with this anymore. So I hope you'll take that into consideration when you tell me to stop talking, or that I don't know the law, because I know enough to know that I could bring a motion without notice to seek the justification of my request based on the law and based on the facts and based on the authorities. And any deviation from that would be an error in law and fact and the probable overriding error.
2, it is ordered the case be sealed. Number 3, seems obvious to this court that it is impossible to hear and determine in a summary way all of the questions of law and fact that the plaintiff has pleaded and made representations concerning. Many are clearly not within the jurisdiction contemplated by Section 23, Sub 1, and Section 25 of the Courts of Justice Act. Accordingly, pursuant to Section 110, Sub 1 of the Courts of Justice Act, this matter is hereby transferred to the Superior Court of Justice.
Five.
Your Honor, sorry, before you leave, I'm wondering if there's an issue of cost to be addressed. You're not entertaining any issue.
I don't think so. Okay.
Thank you.
Court is now concluded.
And I'll be appealing my order. Here you go. You can search. I'm serving you with my notice of witness list and my,
It's being transferred to the Superior Court, so I don't know what.
well, I'll serve it to you anyhow. I'm gonna go file it, and then I'm gonna go seek an appeal of the order that was just made, transferring this matter to Superior Court without jurisdiction.
Okay, well, you can't serve me with the trial record because I haven't been served, and my client has been served with an amended claim, so you can't serve that, you can't, I'm not gonna.
Okay, so I'll just use it with the amended claim then, that way there.
Well, I think you know that you can do that until I have a chance to respond to any amended claim, right?
I didn't serve you with the amended claim.
No,
You didn't take it,
Yeah, I know, but after you serve the amended claim.
right?
I think a defendant is entitled to file a defense to the amended claim before you can file a trial record, because the defense would be in the trial record, so I'm just saying, I
Well-
think you're jumping the gun.
Well, no, because we were supposed to have a settlement conference today, which those are the documents I was gonna file if the judge decided today we were gonna proceed with the settlement conference. And we didn't proceed with it.
We haven't had a settlement.
Exactly, so I can serve you with this at any time.
What is the trial record?
It's my list of proposed witness and the evidence I intend to rely upon on trial, which is to be submitted 14 days before a settlement conference.
Okay, well, why don't we wait till the pleadings are closed before we start, because if the pleadings change everything, you might have other documents you want to submit, right?
Well, okay, it would give you an advantage to see what kind of evidence I'm gonna bring forth, but I'll keep it.
I'm not seeking to get an advantage, I just want to do things.
Oh, I'm not sure that's quite accurate, but anyhow, it doesn't matter because I will be appealing this order made without jurisdiction, which was quite complicated by the manner in which these proceedings were set before the court today. Do you know if Justice or Deputy Judge Young has February? Yeah. That's what I thought.